this is the best part of the program today, is that I am so excited to be inviting two very special speakers. We have Michelle Lerman and also Dylan Rick. And one of the main reasons why, and I'm sure, Michelle, you hear that a lot, is that we all hear about Jeff Lerman, and you guys also have done a commercial real estate symposium in March, and that was so successful. And I was super impressed. And Michelle had done this one segment talking about estate planning. I missed it because I had my own, speaking as well that day, but that's why I'm so excited that you're here. So now I can be focused and listen to you. And welcome both.
Thank you. Great. So I'm going to share my screen and we'll get started. Hi, everybody. Thank you, Helen, for the introduction. I'm Dylan Recht. I'm a partner attorney with Lerman Law Partners, LLP. We're based in San Rafael, if you don't know. I'm sure you are familiar with us from Jeff and all the great work that he's doing. My partner, Michelle Lerman, and I are glad to be here today to share this critical information with you. So what we're sharing with you today is going to impact you, your clients, and really generations to come. So first, I'd like to invite you to use the question and answer box to put any questions that you'd like to see us address during the presentation, just to make sure we touch on everything. And feel free to use the chat as well if you want to let us know anything that you'd like us to discuss. So let's take a quick look at, this is Michelle. So she has written a book. She is Super Lawyers for many years. She's the principal of our firm and our fearless leader when we tackle most of our projects. But we work together as a team. This is my bio. From San Francisco and still live here. So if you'd like to come talk to us, there's a good chance you'll either talk to me, Michelle, or our partner attorney, Sarah Kern, who isn't with us today. So this is how a lot of us are feeling when we are looking at these new changes in tax laws under the Biden administration, or even when you're approaching your own estate planning. But we don't want you to feel that way. So let's take a step back. Everybody needs a basic estate plan if you have any type of assets in California. So usually we would prepare a basic estate plan that's centered around a living trust. So if you're considering any of these advanced techniques that we may talk about later in this presentation, you should first look into your own basic estate plan, which would include a trust, a durable power of attorney if you're incapacitated for your finances, a will to provide guardianship nominations for your children and to pour any assets into your trust, directions for your personal items, and healthcare documents. One thing on this list that I want to make sure that you pay attention to is beneficiary designation forms. If you have any retirement accounts or life insurance policies, you should make sure that you have your beneficiary designation forms somewhere safe. We had a client once who had a retirement account, and the company that was holding that retirement account lost the beneficiary designation form. It was just through a stroke of luck that our client's children found a copy in their files and were able to avoid probate, because a lot of retirement accounts, if they don't have a proper beneficiary designation, require probate court administration after someone's death. Also, having a trust is very critical. We had a client whose mother was in her 80s, passed away. Very simple. She had one condo, but she didn't have an estate plan. And the daughter of that client had to go through a large probate administration. So $80,000, 3 years later, she still received the assets, but it all could have been avoided had she done some proper planning. So I just want to make sure that you have a foundation before you really start to dive into more advanced planning. And I saw in the chat that there's a few of you that hold real estate and LLCs. And I want to make sure that as a foundation for your planning, you should make sure that that LLC is covered by a revocable trust. You can also consider doing some other things, but we'll hold that off until we can consult with you one-on-one, because there's really no one-size-fits-all solution. So what we're going to cover today, we're going to talk about the Temporary Tax Act, so the law that's in place today, the changes that we're going to expect under the Biden administration, and some critical steps for you to take in light of the changes and the information we're sharing today. So right now, we're under the Tax Cuts and Jobs Act that went into effect in early 2018. So this creates a situation where you can leave $11.7 million of assets to your beneficiaries free of estate tax. So that means you can, a married couple can leave $23.4 million of assets without incurring any estate tax. So this law is set to expire at the end of 2025. So even if Congress, Biden does nothing, this law will revert back to what we had before 2018, which is about $5 million that each person can leave free of estate tax. And that would be adjusted for inflation. So we're looking at about $6 million per person. But the Biden administration has been talking about changing this. Right now, you can also leave $15,000 annually through lifetime gifts to any person. And that likely won't change, but I'll come back to that. So just want to make sure that really does expire at the end of 2025. So if you have more than $6 million in assets, you should consider taking action now. So here are some of the proposed changes from the Biden administration. They're talking about lowering the estate tax exemption. So that's the amount you can leave free of any estate tax, down to about $3 million per person, maybe $3.5 million per person. So that would be at $6 to $7 million free of estate tax for a married couple. That's a big change, and that's going to be what's going to be impacting a lot of you. A lot of you previously under the current law weren't going to incur any estate tax at your death. Now, many of you are going to be subject to potential estate tax after your death. There's also been talks about lowering the amount you can leave through lifetime gifting. So right now, you could also leave $11.7 million to anyone. You can give it to anyone without incurring estate tax at your death. The Biden administration has been considering limiting the amount of lifetime gifts to $1 million per person. So that means you can only gift $1 million of assets during your life. There's a chance that this will be retroactive, but it's very unlikely. So if there's gifting that happens from now until the law takes effect, it's unlikely to be subject to the new law. I've heard a lot of experts talk about making it retroactive, and it would be functionally difficult. So we're not too worried about the law becoming retroactive, but there's a chance. So you have to exercise caution if you're going to make any transfers today. So there's also been talks about raising the capital gain tax rates. And I know that's very scary because capital gain affects all of us, and especially us in California with appreciated real estate. There's also, under current law, I know many of you are sophisticated investors, some of you are accountants, and right now there's an adjustment at death. It's what we call a step up in cost basis. So the cost basis that's used to calculate capital gain is raised to fair market value at someone's death. And the Biden administration is talking about taking that away. So let's say you have an appreciated asset at your death. If that asset goes to your children, after this law changes, they would take your basis. It's commonly referred to as carryover basis. There's also been some other talks about changes to how like-kind exchanges work. They're talking about raising the maximum capital gain rate to about 39.8%. And there's also been, although it's very unlikely, there's a proposal on the table from Sanders, Warren, Booker, that would cause recognition of gain at death. So death would actually be an event where gain would be recognized with some set aside, so it would only affect those with what they call larger estates. And I know that's all very scary, but there are ways to address this ahead of time. And with that, I would like to turn this over to Michelle Lerman to go over the critical steps needed to address these.
Great, thank you, Dylan. What a perfect background to set that, and really a background that affects all of us, because those here are real estate investors. We are known as the real estate investor's lawyer, and that's basically, that's the bulk of our clients are real estate investors. We are also real estate investors personally, in addition to having a law firm that handles all of the legal work for others. And what I want you to think about, and I want you to use the chat, and you can go ahead and chat with everyone. What would you say is unique about planning for the real estate investor? What is unique about a real estate investor and their assets? Anybody have any thoughts? What's unique about a real estate investor versus someone who owns a business, selling things, not real estate, or versus someone whose main investment is in the stock market, for example? What's unique? Longer term, you have the, good. You have property tax reassessment issues, right, tax deferral, the depreciation. What about the location of assets? Would they all be right near where you live, or might they be in lots of different states governed by different legal systems, right? So perhaps diversified. And you can go ahead and put it in a chat, or actually, I think you can use the raise hand, and we can see you. Raise your hand. Debt is another one. Thank you, Maxim. Raise your hand if you have assets in, or your clients do, outside of California. Just put yes if you do, and don't answer if you don't. Yeah. So a lot of real estate investors, in fact, I should put in a plug right now. We're actually just selling a property in Chattanooga, Tennessee, and we are actively looking for that up leg, and contingencies were waived. So I'll just put that little plug in there. So a lot of us do. So reviewing the living trust, and as Dylan said, having a living trust really is the foundation. That's not going to change with anything that the Biden administration is talking about. The fact that you need a living trust, because if you have assets in various different states, if you have real estate, you're going to have to go through probate or deal with some legal stuff in all of these different states. Whereas if you have a living trust, you're going to put everything in a living trust, and it's going to be based on where you live. So if you're a resident of California, that's where you're going to do your living trust, but assets all over can go into your living trust. As Dylan mentioned, the LLC, and a couple of you had, I'm sure a lot of you have LLCs, the LLC gets assigned to the living trust, Or if you were to come to us to prepare your LLC and we're doing your living trust, we would prepare your LLC in the living trust. People often think, oh, well, if it's in an LLC, I don't have to worry about probate, but that's not true at all. Any assets that you have that don't have either a beneficiary designation, like a retirement account, or life insurance has a beneficiary designation, or some way to name who's going to get it on title of that document, anything that's in your individual name, including an LLC, including an interest in a partnership, that's all going to go through probate unless you have a living trust. So the critical first step is, if you don't have a trust, or if you have a trust but it was done a long time ago, you have to review your living trust, because all living trusts aren't alike. And this is what I'm always surprised when people say, oh, I'm going to go on Nolo Press, or I'm going to go and, do LegalZoom. I'm going to prepare my own. And what I would ask you, what exactly are you going to prepare? And because all living trusts really are not alike. Raise your hand if you're married. You can just use the raise hand sign. And let me just put this on gallery view, see how many of you I can see. So thank you for being interactive here in this Zoom world that we're getting so accustomed to. So a lot of you are married. And what you want to know is, if I should die or my spouse should die, what does my living trust say is going to happen? And that's what we call the issue here. Should I have a split trust at the first death? In other words, should my trust divide up into separate trusts when one spouse dies? And one type of trust is an all to spouse trust. No split, one spouse dies, your trust says everything goes to my spouse. And then the problem though is, where is it going to go after your spouse? Is your spouse going to remarry? Is your spouse going to marry the pool man? Is your spouse going to marry the young 20-year-old? And so with an all two spouse plan, it's nice and simple. And many of you, especially if you've been married for a very long time, if you have children of the marriage, an all to spouse plan could be perfectly fine. But there are a lot of considerations that go into making that decision, because another type of trust would actually split the assets at the first death, as you can see. And a traditional bypass trust, I started practicing, oh gosh, I don't think I'm going to give you the year, but I can tell you that only 275,000 could pass free of estate tax when I started practicing law. And now, as Dylan said, it's over 11 million and over 23 million for a married couple. We always, when I first started practicing this, and that's why I call it traditional, this is what we always did. Pretty much anybody that came to us has a traditional bypass trust. Could you raise your hand if you have a trust from a long time ago? Any brave people want to tell me if you have a trust from a long time ago? Those people need to, it looks like I'm actually not seeing all the hands. I guess all I can see is is that right? Helen, I can only see the panelists. It looks like.
Yeah, I do see the attendees right now. We have 3
Oh, you do?
hands
Okay.
raised.
Okay. So, so if you prepared your plan a long time ago, this is probably what you have. Let's say you had, and someone asked about law and different, how would you handle the real estate contract in a different jurisdiction if the property is, I guess, in a different state? So this talk is centered around estate planning. Jeff handles all of the transactions, and he would bring in counsel in that state. But a lot of estate planning, these are federal rules, but they're also California specific. But it doesn't matter as much. It matters somewhat, but the key is where you live, where your residence is, and then those assets are put into your living trust. And so this traditional trust, let's just say you had $6 million of assets and one spouse died. In this scenario, $3 million of assets would go into the bypass trust and $3 million of assets would go into the survivor's trust. That basically means that your real estate would be split up. Maybe you could have 50% of each LLC or each piece of real estate in the bypass trust and 50% in the survivor's trust, or you could pick and choose depending on how the trust is written and put all of one type of asset, you know, all of, say, your commercial real estate, our Chattanooga deal, we could put that in the bypass trust and then put our home and other assets all in the survivor's trust. And so you pick and choose. How much can go in the bypass trust will depend on what the tax laws are at the time, and everyone will have an opportunity to come in for a complimentary consultation, and we're going to ask you in advance to show us a copy of your trust. And when everyone goes home today, someone said, I have a trust from 2009 and it's been restated. It doesn't matter that it's from 2009. What I want you to look at, what does the restated trust say? And I want you to look to see, do you have a traditional bypass trust or not? The problem is, here's the problem. If you have $3 million of assets in the bypass trust and $3 million in the survivor's trust, and let's say now the second spouse dies, and let's say that the $3 million, our Chattanooga deal that we put in this bypass trust that was worth $3 million, let's say when the survivor dies, that it's now worth $6 million, and our kids want to sell it. Under current law, Dylan mentioned the carryover in basis, and under current law, our kids would get our Chattanooga deal at the $3 million basis, which is basically the basis that it had when it went into the bypass trust, and then have to pay tax or perhaps do a 1031 exchange or figure out what to do. But there is going to be capital gains on the difference between the value or the asset, the basis when it went into the bypass trust and the fair market value or whatever you sold it for. So it's a carryover basis. So it's a huge tax trap because of the way these were drafted. They were not drafted for the large exemption amounts that we have. But the nice thing is that with the bypass trust, you don't have to worry about the 20-year-old that your spouse is going to remarry. At least the bypass trust, sorry, I'm so jaded. It's a good thing my husband's not listening to this. But the bypass trust does have protection. And as real estate owners, why do you have an LLC? Because you're worried about the protection. Well, the bypass trust can add critical protection that the all-to-spouse plan does not. And so what we've done is for today, today's laws is we've adapted the bypass trust, and it looks very similar, but without the tax problem. Because what we do is we still have what we refer to as a protection trust. Legally, it's a Q-tippable AB trust, but there's lots of initials in there. It still has the protection. The assets are still split. There would still be $3 million in the protection trust, $3 million in the survivor's trust under my scenario. But if our Chattanooga deal were worth $6 million and the second spouse later dies, under these rules, if you go ahead and make a tax election because of the way it's drafted, I know some of this can get complicated. That's why we're letting you consult with us. You get a step up in basis under current law. You don't get the carryover basis. What that really means, what the bottom line is, you've just avoided the capital gains problem, and that's all under current law. So you might be thinking, well, under current law, Dylan said there's a temporary law that expires at the end of 2025. Biden might change this. Maybe I just should wait. Maybe I shouldn't do my estate planning at all because I don't know what the law will be. That's the wrong answer, okay? I figured you knew that I would say that. That's the wrong answer. What you need is a flexible trust. And that's why if you look at the screen, you'll see Q-tippable. Q-tippable. That does it, so this type of plan is flexible, that if you need a traditional bypass trust, believe it or not, all you would have to do with this type of plan is just not make a certain tax election after the second spouse, when the first spouse dies. So what you really want is, don't delay in your planning, just make sure that you have flexibility built in. And it really is like a teeter-totter in the playgrounds. It's really this balancing act of, there's benefits to an Alta spouse plan, there's benefits to a Q-tippable trust, and it really, that's why you can't just go and print something off of the computer. So in either of these types of trusts, ongoing trusts for children are critical, especially, again, why do you have your real estate in an LLC? And if you don't, you should talk and get a consultation about that. Why? For protection. You can do, this is probably one of the most important things I'm going to tell you, although I've got in the critical step 2, I've got some pretty critical things to tell you. You can do asset protection for your children that they cannot do for themselves, even with the very best LLC that they create. Because asset protection is not bulletproof, and creditors can still get to things even though it's in an LLC. And yes, creditors can still get to things with an ongoing trust for children, but it is so much better for asset protection, especially in a state like California, community property laws. And if your children should get divorced, have a bad marriage. And what do I mean by an ongoing trust? This is the other thing I want you to look at in your own plan. Does your plan say that the assets go to your kids like at age 25 or 30? It really, and again, I should have said this caveat earlier. I'm not intending to give you legal advice. As Dylan mentioned, we don't know enough, and there's no just one size fits all solution to these things. So be sure whatever you do, don't act on what we're telling you. Be sure that you get legal advice about your situation. But one of the things we're known for in our practice is lifetime trust for children. And that doesn't mean that your kids can never use the money and that you're just skipping over them and it's their money, their assets and their real estate's going to be all locked up. It doesn't mean that. It just means that they could, if they wanted to, be the trustee of their own trust, but the trust doesn't go away when they reach a certain age. It's an irrevocable trust that protects them for their lifetime. And if it's drafted in a certain way, you can optimize the protection that you're providing for the kids. And if this is something you want to talk with us about, just write down this: a fully discretionary lifetime trust, a fully discretionary lifetime trust for kids. These are all provisions that we put within the living trust. Let's get to the crux of the conversation today. Let's talk about critical step number 2. So it is, while Dylan just explained it perfectly, the uncertainty, a temporary law. What that means is that even if this administration can't pass anything, the current law is going to expire, and we will probably be left with an exemption of around 6 million. The only reason I say 6 million is, as he mentioned, it goes down to 5 million, which is pre-2018 law, plus there's a cost of living adjustment. So we're assuming 6 million. So as he said, anyone who has assets more than that, or if you're married, more than 12 million, should seek counsel about removing assets from your taxable estate. Now, don't remove anything that you're going to need, but there are ways with using something called an installment sale to a trust for your kids that you set up now. There is a way to continue getting some stream of income, but in general, I never recommend a client give up something that they're going to need for their own lifestyle. Remember, you're the most important, your clients are the most important, not what you pass on. But once we know that you're taken care of and you're comfortable, this second step is something that you'll want to look at. So how do you do this? You're probably wondering, how do you do this, Michelle? How do you do this? So what we do is in addition to your living trust, we set up an irrevocable trust that would be set up now. Typically, it would have a separate tax ID number. And the irrevocable trust would be for the benefit of your children, typically for the benefit of your children, although we could also set up for the benefit of a charity, and that's called a charitable trust. And you could do this, you could set up, Dylan, you can forward the slide if you can. Yeah, and you could do this as a gift, you could do this as a sale. So what do I mean by that? You simply take a part of your real estate, like we have this Chattanooga deal that I'm talking about. I'm hoping someone out there is going to have some good deals for us to look at by the time this program is done. I don't have to transfer all of it, but I could transfer some of it. I could transfer maybe 5% of our LLC interest, for example. And by doing that, I get a discounted value on the transfer. So Dylan is my math guy, not me, but let's just say it were worth $1 million and I'm giving 5% of it. So with this discounted value, I get a separate appraiser to appraise it and say, what is an appropriate discounted value if my children are only being gifted 5% of this LLC? They don't have any control. Who wants to own 5% when someone else owns 95%? How could I sell it? It's hard to sell 5%. So there's got to be some intrinsic discount, and that's what the appraiser does. And I want to point out that under the Biden administration, there's talk of doing away with this. And one of the huge benefits of gifting now, especially for clients that have, say, estates of over 20 million, and the higher up you go, the more important it is to do the planning now, is when you die, you're losing out on a lot of the opportunities that you have when you transfer assets now to an irrevocable trust, especially if you transfer a minority interest. We could structure it as a grantor trust, a non-grantor trust, a completed gift. These are all details that we would go into, but I want you to understand just kind of the landscape, that there are a lot of different tax strategies that can be used. So you might be saying, yes, let's do it. I want to do this. How great that if I were to get, say, real estate out of my estate, it freezes the value, because to the extent I've gotten it out of my estate, that is no longer an asset of mine. So all of the appreciation I have also gotten out of my estate. I can do it, as I said, an irrevocable trust drafted right. It can have protection. I can structure it as a lifetime trust. And I find this is one of the #1 mistakes other lawyers make, is not thinking of these lifetime trusts that are so valuable. I can set it up, if I set it up using the rules under the IRS code of a grantor trust, I can be getting, if I transferred it and I do it as an installment sale, I can be getting interest payments on a note that my kids owe me, the irrevocable trust owes me, and yet the income payments that go to the irrevocable trust are not subject to income tax, because it's a grantor trust, and it's purely provisions that we put into the irrevocable trust if this is one of our goals. And so any tax ramification of a transaction between me, if I'm the grantor, and the trust that I create are ignored for income tax purposes. So income tax, so the payment to me of the income stream of the interest and all from the installment sale, it can be structured so you don't have income tax on that. And to the extent that I continue paying the income tax, we have a client who is now receiving thousands and thousands of dollars completely income tax free, and the grantor is paying all of the income tax on that. This is at the end of an installment sale. It's all paid off. And so the grantor is no longer getting any installment payments, and the real estate is now owned in an irrevocable trust for the benefit of the children. And all of that income is coming to the kids income tax free. Now, the grantor pays the income tax. Okay, the kids don't, but the grantor is. So it's not as if doing this, you're avoiding the income tax. You're not. Someone's paying it, but the kids aren't. And that's another way, when the grantor pays all of that thousands and thousands of dollars in income tax, it gets more out of the estate, and it's not considered a gift. So the downside, though, of doing this is that under current law, if you died owning that, and Dylan, you can go forward just one. The downside, if you die owning a property under current law, as we said, the benefit is you get a step up in income tax basis. I have a little caveat because in 2008, we experienced the step down in income tax. So a lot of professionals now just say an adjustment, because it could be up, it could be down. Hopefully the real estate is of higher value, not lower. But so if someone were 90 years old, I would be hesitant to go ahead and transfer more assets now, because anything that the 90-year-old keeps, especially if the 90-year-old isn't in good health, is going to get a step up in income tax basis. As Dylan explained, once you gift it, they get, the kids get your basis. It's a carryover basis. It's not a step up to the fair market value when you die. It's your basis when you owned it. So that's the downside. And that's why, as Dylan said, there's no one size fits all plan. You really have to evaluate and understand what's best for your particular situation. So what did we learn? Well, we know that the law is going to change. And because we know that, for anyone with a sizable estate that's going to be subject to estate tax, now is the time to act. There's a short window. Dylan also mentioned, sorry, Dylan, I keep saying you also mentioned, but we don't know if the changes might be retroactive, but we don't think so. So that's just a caveat you have to be aware of. So for example, if Biden changes the lifetime amount you can give away to $1 million, currently it's the same. You can gift it during your lifetime or die with it, and the number is the same, the amount that can pass tax-free. But if Biden were to change it and say, no, only $1 million can be passed during your lifetime, and maybe 3 million when you die, if you go ahead and gift 2 million, there is a risk that maybe there would be a gift tax on the 1 million, because the law changed, and only if it was retroactive. The experts I'm speaking with, and I don't know, I know we have a lot of experts right in the room, don't really think that that's very likely, slim to none, but I want you to be aware of it. And so we've discussed what the changes are. And if I had to summarize the changes, I think a lot of you would agree. I'd say higher taxes, including estate taxes. And the steps are: take out your trust. And certainly if you don't have a trust, and you are in real estate and you own real estate, you've got to talk about getting a living trust. As Dylan mentioned, the fees were about $80,000 to put this condo through probate, 3 years. It was completely a mess. And that trust could have been done in $3,500. So there's a huge issue. Cheap for trust doesn't necessarily mean better. And you really want to have someone who understands real estate investors, understands the interplay between property tax, income tax, the estate tax, and really understands what the planning is. And then if you do have a large estate, think about acting now. It's never too early to act, but unfortunately, a lot of times it can be too late. We are offering you to, if you'd like to consult with us, if you have an attorney already, go back to your attorney, have it relooked at again if you're happy with your attorney, but to really get started on your plan. We didn't talk about it, but I don't know how many of you have your real estate in an IRA, or yeah, I guess it would be an IRA, not a 401k, but the Secure Act came out and it was completely eclipsed by other things going on in the world, but that changes the rules for retirement accounts and estate planning for retirement accounts. So I'm happy to offer you that. When you get started on your estate planning with us, you'll get a free copy of my book. We don't offer complimentary consults to everyone. So if you want to take advantage of that, you can go on now to our Calendly link and go ahead and get that scheduled, and you'll see that on the screen. Or email us. You can email Dylan at lermanlaw.com or Michelle at lermanlaw.com. So let's see, please show the contact page again. Email is the easiest. Dylan, if you want to just forward it to the very end, Michelle at lermanlaw.com or Dylan at lermanlaw.com, and that really is the easiest. Our main office building is in San Rafael, but we handle estate planning, real estate, litigation, partner disputes, and we handle that all over the state of California. We have offices throughout the Bay Area. And now we know how well Zoom works. We've always done a lot of Zoom meetings because we've always had a huge focus all throughout the Bay Area and Southern California. And for our syndication practice, I should also say that in our syndication practice, it's a national practice. And so we can definitely help you. If you haven't heard Jeff speak, he just spoke this morning on joint ventures. And I think he also has some free reports and recorded webinars. Reach out to him. If you have partners and have any concerns about disputes, speak with us early so that we can help you try and avoid it. But if it can't be avoided, we also do the pre-litigation and the trial work in litigation. So thank you for having us. And we have time for questions.
Yeah, thank you so much, Michelle and Dylan. This is so informative. And yeah, just a reminder that Jeff Lerman had actually spoken to our group before regarding joint ventures. So I'm sure a lot of people remember that. The first question, Ellen is wondering just to see if you will be sharing these slides with us. If you do, then we can email it out. Okay,
yep,
great.
We can
I'll get a copy from you later. And Patricia had asked, can you address what happens to the base? Oh, I think you kind of talked about it already just now.
Yeah, but that's a good thing Patricia wanted to know what happens when one spouse dies. When one spouse dies with community property, you get a full step up in basis for all of it. And that's the other reason why you need an attorney is, although there's the presumption with that situation where when you're married and getting a step up, there's a presumption when it's when it's joint tenancy, there's a presumption that it's community property. But if really it is community property under California law, it's best to do a transfer deed from joint tenancy to community property and then put it into the trust. But under current law, you get a full step up in basis on anything in your own name.
Great. What is the normal range of fees for administering a trust?
I would say it's a fraction of probate. It's hard to say, a normal range. We've done it for $1,500 and we've done it for thousands and thousands of dollars that it goes on for years and administered, multiple properties, but it does not compare to probate.
Yeah.
Our minimum fee in probate, the minimum fee is about $20,000 to go through probate, and it could be $80,000, and the executor gets probate fees also. So.
Yeah. That is also one of the reasons why us as the real estate professional, it's so important for us to remind our clients to set up a proper living trust as well.
Yep. And we didn't even get to talk about property taxes. That'll be the next talk, but maybe you guys are all sick of hearing about Prop 19.
Yeah, there are just so many, I think, tax issues that everybody's really concerned about these days. Obviously, I always say that it is really hard to do tax planning in a way for long-term tax planning because it just keeps changing. But it's funny, that's what Jesse is saying too. Why is it legal to make retroactive laws? It should be illegal.
I don't think it is, to be honest with you. I think that would be the problem.
Mm-hmm. Yeah, I agree with you. I think that will upset a lot of people. And do you anticipate California passing an estate tax to cover any gap between the federal exemption and some numbers such as 3.5 million?
Let's see, let me look at my crystal ball. I wish I had a crystal ball. I don't think so. I've heard not because of the what you would need in California in order to pass that. So, and we don't have offices in Sacramento. I'm sorry.
You have office in Zoom though. Can you do Zoom?
Yes, I have offices in Zoom. And it depends, you know, if this, for example, were for your mother or your father, and you've got siblings and they're going to leave more to you than your siblings, or if maybe there's a potential of incapacity, you know, certain situations are just I should know you. But on the other hand, we have done tons of estate plans for people in Sacramento. They're young, they have various apartment buildings. It's, you know, everything going to the other spouse, then going to their kids. So certainly we can help you. I'll always defer it to someone else if it's not in your best interest to use us. But yeah, Zoom is easy.
Great. Is there, I'm curious, I know there are more questions. Maybe, is there a dollar amount that you would say, hey, once you hit this much activity, properties or estate, then you definitely should start talking to an estate planner? Because some people might say, well, I only own 1 or 2 properties. Maybe I should.
Exactly. Helen, that's such a good question. I would say we represent parents. So if you're a parent, you need to have a estate plan. At a minimum, you need a will, but I can also show you where you can get a free statutory will. You don't need to pay Novo Press or any company. So if you're a parent, so that's not a dollar amount. Once you buy a home, you should have an estate plan. And that reminds me, because it's like the, what is it? The shoe peddlers, kids without shoes. Our son bought a home a few years ago, and they keep reminding me I need to get a trust done. I need to get a trust done for him. I'll give a plug for him too. Everybody look up Scary Pockets. It's they get millions and millions of views, and that's his latest venture. It's very exciting. Scary Pockets. Ryan Lerman.
Awesome.
So yeah. Oh, and then Helen, a dollar amount. I would say buying a home. And then other than that, I would say, I probably wouldn't say a dollar amount. I would say once you buy any real estate or you're a parent, that's when you should have an estate plan.
Yeah, I absolutely agree with you. We also work with a lot of first-time home buyer, young homeowners, and we always have to remind them that as soon as you buy something, you need to be protected in some way.
Yeah, because if they take title, for example, as joint tenants or husband and wife, community property, right of survivorship, it goes to the other, they've lost all of the potential protection afforded by a split trust. Absolutely. And so they should at least understand the benefits and what they need and put it in a trust. Also, if they died together, there would be a probate.
Sure.
Joint tenancy only gives protection if there's a surviving joint tenant. There is also a transfer on death deed. I don't know if you're familiar with that. It's a temporary law that's been extended, but very limited in use. Typically, we want to use a living trust.
Great. Okay, see if we can answer. I want to make sure I answer all the questions, but here's one. Can you touch on IRC 170, your level of involvement drafting structure?
I'm sorry, I don't see that question. Say that again.
It's under the chat. It's in the chat box. It says,
Oh, it's in the chat box.
yeah.
Oh, no, I'm going to leave that to the CPAs in the room.
Okay. Oh, great. And maybe Shirley did ask something about like if I have a trust from 2009, which has been restated, is the original.
I mentioned that already.
Oh,
Yeah,
yes.
I addressed
right.
that.
All right. I think we have answered all the questions and we are right on time. It's at 11 right now. Sharp. Perfect.
If you were all in person, I would tell you stand up and give yourselves a big round of applause.
Absolutely.
You should probably stand up anyways.